Hello, my name is Osha. I like talking about American presidents, and today I'm not going to be talking about American presidents, but I'm going to be discussing the Fourth Amendment. I'm continuing my discussion on the Fourth Amendment, which is part of the Bill of Rights, which was given to us by our fourth president, James Madison. Uh, and of course, the Fourth Amendment is one of the most explored and most litigated amendment of the Bill of Rights, and it remains one of the most complicated. I've been taking it in bits and pieces. So today I'm going to be discussing probable cause. Probable cause is very important, and of course, there are a lot of elements in the Fourth Amendment. And so what I'm going to do is today I'm just going to start off by reminding us of what the Fourth Amendment is. I'm going to recite from memory. Again, this is very important for us all to sort of memorize what the Fourth Amendment is. And, the words that our founding fathers put in the Fourth Amendment, in every amendment, turns out to be very important because these are examined, explored, interpreted in courtrooms by judges. So today I'm going to be talking about the Fourth Amendment, and later on I'm going to look at a very important court case, Supreme Court case of 1949. 1949, Harry Truman, President Truman was our president then, but the case I'm going to be looking at, which really defines probable cause for us, which we'll be discussing, that's Brinegar versus the United States, 1949. But let me start off with reciting what the Fourth Amendment is from memory. It's good for us all to memorize the Fourth Amendment. Very important in these times, right? So here it goes. The Fourth Amendment. It goes, the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, and particularly uh, describing, sorry, take that back. You see, it's hard, but it's so because I remember the significant parts, right? And when I recall that, oh, I've skipped a portion, I can go back. So I digress. I apologize, right? Let me restart. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. So that's very important. So effects, that's very important in the case I'm going to be discussing today. That was what I wanted to focus on. Effects, it's going to feature in what I'm discussing today. Warrants, warrantless searches, it's going to feature in the Brinegar versus United States case. And effects, so effects um, means it's an old way of saying personal property, right? Your property. So the case of Brinegar had to do with a car, right? It had to do with an automobile, right? A vehicle. So personal property, movable, tangible property. So that's what effects are. So the Fourth Amendment is not only dealing with your home. Most people think that it has to deal with your home. So importantly, the Brinegar case, I'm discussing that because it's a landmark case that helps us define probable cause. Probable cause is a very difficult definition, and from the Brinegar case, it comes out. It tells us that, well, probable cause is nothing. It's not a technical term. It's nothing. It's not a technical concept. It's not from technical people, but it has to do with factual and practical considerations of everyday life. That a reasonable and prudent person, right? Reasonable and prudent, affecting a reasonable and prudent person and his conclusions, right? So reasonable, you see how it comes up a lot. An illegal search. just says that, well, that search was unreasonable, right? And so the Brinegar case helps us. I think one of the definitions of probable cause that the Brinegar case gives us was, um, it says that it where there are facts, right? Facts, factual knowledge within, facts and knowledge, facts within the knowledge of the officer. That's how it puts it. Facts within the knowledge of the officer, because the officer is a police officer, the person who is trying to seize you or trying to effect an arrest. Um, so he has facts of and circumstances within his knowledge, uh, which which are reasonable, right? Which are reasonable, that allows him to make a reasonable conclusion, that a crime is being committed, right? He has knowledge within his possession, right? He has uh, the facts and circumstances within the officer's knowledge, and which are sufficient, right? And suspicion, which is and suspicion causing him to have a suspicion which is sufficient for him to draw upon a reasonable, right? A reasonable belief. To have a reasonable belief. So there's that belief, and it has to be reasonable. So there's so many, sometimes, when one's looking at probable cause, there's so many words going into it again, and they say it's not technical. So to have a reasonable belief that a reasonably cautious and prudent person, would be able to draw a conclusion that a crime is being committed. Basically, those are a lot of the elements that are within probable cause that we draw from Brinegar. So again, it's not technical, um, and the standard, from Brinegar, it tells us that it's between, it's between reasonable doubt, which is the highest standard, which is the standard required at trial, by the state for conviction. That's beyond a reasonable doubt. So it's lower than beyond a reasonable doubt, and it is higher than reasonable suspicion, right? So beyond a reasonable doubt is the standard to convict at trial. And the thing about probable cause that we also get from um, other cases is that hearsay can be part of probable cause, right? Hearsay can form probable cause. For instance, the judge, when they want to issue a warrant, right? When a judge wants to issue a warrant, the officer might swear an affidavit and write, well, he suspects that there's a crime going on, and he's got an informant. How did he know it was an informant who told him? Is that informant reliable? Yes, it's reliable, things like that. And so these are affidavits, that's oath affirmations that the police officer will swear to, and the judge will consider the totality of the circumstances. So when the judge wants to issue a warrant, right, or magistrate, he's a neutral judge. He's not a buddy of the cop, right? He's not an adversary or an opponent of the subject of the warrant, the suspect. So he's an impartial judge, right? He's neutral. So he'll consider the totality of the circumstances. He'll consider the oath, right? The oath, the sworn affidavit or affirmations. That's the oath and affirmations portion of the Fourth Amendment that I recited. So he'll consider the oath and affirmation of the police officer or whoever, and he'll consider the informant, right? Is the informant a reliable informant? And he'll consider again the totality of the circumstances, right, before he issues the warrant. So something Brinegar brings out again for us is the reason why it gives that probable cause is that middle ground. So probable cause, it's not extreme, right? It doesn't allow beyond a reasonable doubt, right? That, okay, you've got to be sure. That's the standard to convict when you go to trial. Because if that were the case, then it says that you'd just be hamstringing the police officers, right? Officers won't be able to do their jobs. They won't be able to, catch crime. because they will be too cautious. Yes, you want them to be cautious, but they won't. They wouldn't have that leeway to be able to exercise some level of reasonable, cautious judgment, right? If they needed reasonable, beyond a reasonable doubt, and beyond a reasonable doubt might also not protect the police officers. It might also not allow the police officers to be able to protect the community, right? If he suspects there's crime and he needs beyond a reasonable doubt to be able to secure an arrest, right? Then he might not be able to protect the community, right? Beyond a reasonable doubt, 100% is you see it, it's right there, you can catch the person red-handed. But, you know, it doesn't allow that reasonable suspicion that, okay, you have facts and circumstances within your knowledge, that can raise, that level of suspicion sufficient for the officer to have a reasonable belief, which a reasonable, prudent person, right, would be able to form, right, that some crime is going on. So that's the notion of the having that probable cause standard. So it protects the safety of the police officers. In case there's a crime going on, there's criminal activity, they just don't turn a blind eye, right? It also protects the community, right, for public safety. At the same time, it's not so um, it's a middle ground, right? It's a middle ground and not so low. If the bar is too low, then the police officers might, the make rash and capricious decisions, right? It might subject innocent citizens, right? Law-abiding American citizens, innocent people. Might be subjected to rash and unreasonable interferences in their privacy, right? They might be subjected to unfounded accusations, charges of crime, when they're actually innocent. They're not doing any, uh, they're not causing any danger. They're in their homes, not causing any, committing any crime, and then all of a sudden they're raided by cops, right? So privacy, you see, Brinegar considers, the justices consider privacy. That privacy is very important, right? So we don't want the cops to make rash and unreasonable interferences in our privacy, right? Privacy, that's part of the Fourth Amendment. That's part of our rights, right? Our liberties. So, and we don't want to just be subjected to the whims and caprices of law enforcement charging us with unfounded accusations of crimes, unfounded crimes. So that's part of why the standard is not too low to reasonable suspicion. And so probable cause is the middle ground, right? Again, probable cause, it incorporates notions of they're factual, it's pragmatic, it allows uh, it's based on reasonable belief, right? A reasonable belief that a crime is being committed, and it's based on a reasonable person's understanding, right? A reasonable and prudent and cautious person, not somebody who's irrational. So it's factual. It's based on factual, practical, knowledge. Nothing that's delusional, right? So it's based on practical, everyday understanding of life, everyday life. How the reasonable, prudent, and cautious person observes life every day, and these are the circumstances, right? And I'll do a subsequent video and give further examples. So I'm just giving the broad definitions today. So I want to be able to get through the whole discussion of Brinegar and um, the case of Brinegar versus the United States. So Brinegar was a guy who, um, this is a 1949 case, and it's interesting. It says that he violated the U.S. Code 27 USC 223, which had to do with liquor, illegal transportation of liquor across state lines. That deals with prohibition. So I don't know why that was still there, since prohibition had already been been eliminated with the 21st Amendment. But anyway, that's what Brinegar deals with. So that so there was a police officer who was observing Brinegar. Brinegar was known to the cops, known to the community as, a criminal who dealt with, transportation of illegal liquor. So that it's reasonable, since people already knew what he was involved with. It's reasonable for the police to be suspicious when they see him driving. So he's known to normally transport liquor, right, illegally across state lines. So he is. So a police officer observed him that he was transporting. He was in his vehicle, and there was a case jutting out of his trunk, and he could observe a case in the rear view, uh, uh, through his rear view, that there was a case, right, in the back of his car. So the police officer stops him. So he had a reasonable suspicion. That's where it is. He had a reasonable belief that it was that some kind of crime was being committed. He didn't have a warrant, and so he looks and he sees it's liquor, and he arrests him. Uh, so Brinegar gets convicted for illegally transporting liquor, but Brinegar appeals. He challenges, saying that, well, that the officer lacked probable cause. So it went all the way to the Supreme Court that he lacked probable cause. He didn't have an arrest warrant. It went all the way to the Supreme Court, but the Supreme Court said the arrest was reasonable, right? Again, why was it reasonable? Based on the facts and circumstances. Brinegar was known to be a transporter of conveyor of illegal alcohol, of liquor illegally across state lines. So he was known for doing that. And the police officer saw, the cases of alcohol, that his car was heavily loaded with, with cases, and the police officer has an idea what, cases are, especially given that this is the known trade of Brinegar, right? And so he could see it right there. So he had a reasonable belief, right, that a crime was being committed, that Brinegar was violating the law, was breaking the law, was committing a crime. And in this case, it was a violation of 27 USC 223. USC means US code, by the way. And that's like federal law, which I got to study a lot, in my job for the government. I guess I don't have to do that. But anyway, yeah, so I got to study that a lot, the US code, and there's so many of them. But anyway, so yeah, um, so that's what Brinegar was about. Now, interestingly, there was one justice who dissented. That's Robert Jackson. Justice Robert Jackson said, well, that because in this case, right, uh, in order to that reasonable belief, right, because the Fourth Amendment protects us and says that, look, if there's probable cause, then the police officer should go and get a warrant, right? So this was a warrantless search. It was a warrant. He didn't have a warrant, right? But he had probable cause, right? So there's certain exceptions to having a warrant. So in this case, and there are things like Terry stops and plain view and other things, plain sight, plain field. These plain view doctrine, this came in the 1970s. I'll do subsequent videos because that's another topic entirely. I was just using Brinegar to discuss the acceptable definition of probable cause. Now, um, so probable cause here worked because the police officer still had to have a well-grounded belief of the suspect's guilt, and in this case, it turned out to be accurate, right? His well-grounded belief in the guilt of the suspect, that Brinegar, it was a reasonable he still had a reasonable belief that Brinegar was committing a crime due to the facts and circumstances, his knowledge of Brinegar, and the fact he could see, cases. His trunk is full, the car is heavily loaded with something. He didn't think it was water. That he'd be transporting water across state lines. So, um, you know, so he had a well-grounded belief, to validate his reasonable suspicion, based on the facts and circumstances, sufficient, right, uh, to have a belief uh, to which a reasonable, cautious, and prudent man would conclude that a crime is being committed. However, one justice contended with the outcome, and that was Justice Jackson. In his dissent, he noted that many times there are many illegal searches of homes, of vehicles, of automobiles, of persons, in which innocent people, right, their rights are violated, and no crime, no evidence of a crime is found, right? No arrest is made because no crime was found. No evidence of a crime was discovered. And the courts, they don't make it to the courts, and you know nobody talks about it. Nobody knows of these, but they happen every day. And his attitude was that the case of Brinegar allows, just because, the case of Brinegar where there was a warrantless search and arrest, and in this case, there was evidence of a crime was discovered, um, that it seems to allow a low standard that would lead to further subsequent violations when warrants aren't required. And I've already talked about the basis for getting a warrant. So Justice Jackson thought that, well, these searches, without probable cause being a technical standard, right? Because probable cause, again, it's not a technical standard. Um, uh, it doesn't protect citizens enough. It doesn't protect innocent people enough from interferences in their privacy or from the uh, exercise uh, of of capricious and whimsical uh, officers, just overreaching. Right? It doesn't protect American citizens or innocent people, law-abiding people. Because we still have a right to privacy. We don't want to be violated with just interferences uh, in our, private space. Right? That could be our homes, our papers, you know, uh, you know, and our persons and our effects. So basically, that's Brinegar and probable cause. I want to stop it here. So you see how probable cause can be very complicated. You see here how a warrantless search was justified because the justices thought that, well, there was a reasonable belief, right? There were facts and circumstances sufficient for an officer, with his knowledge and trustworthy information to be able to have uh, a reasonable belief that a crime was being committed, and he did discover it, and he didn't have a warrant, and that worked out. And that's basically Brinegar defining probable cause for us. So again, probable cause has to do with having a reasonable belief, right? It's a reasonable belief. It could include a hearsay. Hearsay you can't use in a court. Why can't you use hearsay in a court? Hearsay is like evidence or word testimony from information from a third party who tells a cop that there's a crime going on here, right? It's an informant. Now, you don't use hearsay in a court because that informant can't be cross-examined. They can't be cross-examined under oath. So that's hearsay. It's not allowable in a courtroom, but it's allowable for probable cause to be able to obtain a warrant from a judge. Now, in Brinegar, there was no warrant, but it turned out that um, the police officer, was thought to meet the standard of probable cause, which is facts and circumstances sufficient to form um, for a person of a man. They like to use man a lot, for a prudent man of reasonable caution, to form a belief that a crime is being committed, right? So, for probable cause, a crime has been committed. There's evidence of a crime. It's not that a crime will be committed in 2 days, in 3 days, that there's a crime, right? It's something factual. It's based on factual. It's practical, that there's a crime, there's evidence of a crime. And that's what the probable cause standard is. Um, and of course, we need that. That's required when officers want to come into our homes. Again, I remind us of what the Fourth Amendment is. Let's try and memorize the Fourth Amendment. It's for our protection. That is the right of the people to be secure in their in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the person or things to be seized. And that's the Fourth Amendment and the probable cause standard. I'm going to continue and give other cases. So this is Brinegar. I used Brinegar versus United States of 1949 just for the definition of probable cause. Probable cause, again, is very it's tricky, right? It's very tricky. But note, probable cause is the middle ground. It doesn't reach the standard of conviction in the courtroom. A criminal court case requires beyond a reasonable doubt, right? Proof beyond a reasonable doubt. It's not up to that standard. At the same time, it's higher than reasonable suspicion standard, the reasonable suspicion. And I'll do other videos just expounding on what reasonable suspicion is. My name is Olurotimi Osha. I like talking about American presidents, and I also draw attention to color of law violations, pivoting on subornation of perjury and fraud on the court, which I suffered from rogue cops who came to my home without probable cause, without an arrest warrant, violating my Fourth Amendment in my home on May 16, 2023. And then the police actually framed me, manufactured a crime. They induced me, they falsely imprisoned me. They had no probable cause, so they violated my home. I should have talked about the castle doctrine. So under the law, probable cause, the Fourth Amendment, the notion surrounding it, it's protecting us in our homes. They arise from Old English uh, common law notions of our homes being our castle, and that castle doctrine still applies um, today in a lot of states, right? In the state of Maryland, right? Your home is your castle. So you have a right to be secure and protected in your home. So my rights were violated in my home, in my castle. The police manufactured a crime. They planted evidence, created false witnesses, a lunatic criminal, uh, an illegal alien. His name's Gurma Shumi, assaulted me, and they suborned him to fabricate a peace order. They suborned another lunatic man impersonating as my uncle when he's not. There's a court affidavit from my mother that Jide Iwari, a Howard University professor, is not my uncle, and he filed a malicious um, fabrication, perjured information, and emergency evaluation petition as pretext to allow rogue cops, Montgomery County Police, and rogue Department of Navy officials, including Nathan R. Brown, uh, uh, Nefertari McBride, under instruction of Kirsten Risbeck and Jamie A. Simon, in collaboration to violate my privacy, to swat me. So I was swatted in order to obstruct justice in a DOD and Department of the Navy and EEOC complaints that I had filed against against rogue Department of Defense and Department of the Navy senior leaders and executives who had harassed me and were violating my constitutional rights. And they swatted me in collaboration with rogue agents of the Montgomery County Police Department and Montgomery County State Attorney John McCarthy. And they used a rogue judge, a crooked judge, Judge James A. Bonifant, to violate my constitutional rights in my home and to frame me with a crime I haven't committed. Uh, I'm looking for justice. The media hasn't paid attention to it because we know the corporate media is bought and they're corrupt. If you can share this information and help me gain justice, I would be grateful, and I'll keep you posted. Thank you.